Hey there, I'm estate planning attorney Paul Rabelais, and in this video I want to talk about how you can authorize a trustee to make trust distributions after you pass away to your surviving spouse, your children, your grandchildren, or other beneficiaries of trust pursuant to the health, education, maintenance, and support standards. So let me give you an example. Let's say a husband has a $6 million estate, and let's say he has a wife whose name is Judy, and he has 3 kids, but let's say Judy is his second wife and she's not the mother of his 3 children. And in his mind, what he's thinking is, yeah, I have a $6 million estate. My wife, Judy, doesn't have nearly that much. She has maybe $1 million or $2 million of assets. So the husband's thinking, yeah, if I pass away before my wife, I want my $6 million available for my wife to take care of her needs for the rest of her lifetime. But then when my wife passes away, I want whatever's left out of that $6 million to automatically revert back to my 3 children. But also he's thinking, I don't want my children to get that in a lump sum. I want it to be in a trust for them, and I'm really not comfortable with them getting a lump sum until they're 60. So what the husband does, he sets up his estate plan, let's call it through his living trust, and he uses the common health, education, maintenance, and support, HEMS, we'll call that the HEMS standard. He uses that HEMS standard in his trust instruments so that distributions can be made to his wife after he dies for the rest of his wife's lifetime, pursuant to that health, education, maintenance, and support standard. And then after both he and his wife, Judy, pass away, then distributions can continue pursuant to the HEMS standard for his children until his children reach the age of 60 when they get their share of the trust. Okay, so while we're here to talk about this HEMS distribution standard, I can't get through this video without first talking about how the husband's trustee decision is important, because who he selects as the trustee of this trust after he passes away, it's important because it's that trustee that has the discretion, that has the authority to determine whether a distribution should be made to someone pursuant to the HEMS standard, health, education, maintenance, and support. So that trustee decision after husband dies and things are in trust for his wife, Judy, is Judy the trustee where she can make distributions to herself pursuant to the HEMS standard? Or is Judy and one of his adult children co-trustees, so it takes both of them to authorize a distribution? Is the trustee going to be another individual? Is the trustee going to be a trust company? So that trustee decision is really important, but we're not here to talk about that. I've made a lot of videos on how you should select a trustee, but let's get back to the health, education, maintenance, and support standard. And what he's thinking is, I don't want my $6 million drained by my wife after I pass away. She's got a little bit of assets as her own. Let's say she has $2 million of assets of her own. And what's going through the husband's mind is, yeah, she may need that $2 million that she has for her needs, for her long-term care needs. And I just want to make sure she doesn't run out of money. So I want my $6 million of assets to be able to support her for the rest of her lifetime. And then when she dies, I want it to go on down for the benefit of my children. So he's thinking, this HEMS standard, he likes the idea of it, but can he define that a little more? So perhaps after he dies, the HEMS provision for his wife is a conservative HEMS provision. And in that trust for his wife, he adds language like, the trustee shall consider the beneficiary's other available financial resources before authorizing any distribution, and no distribution shall be made if the beneficiary's needs can be reasonably met through other means. And he might go on to say, it's the settlor's intent that this trust be preserved and protected, and that distributions be made conservatively and only when clearly warranted under the HEMS standard. So that tells the trustee, hey, consider the wife's, Judy's, available resources, consider resources that she has available before you start making distributions from the husband's estate to wife, and that will preserve more of the trust for the husband's children after his wife passes away. So he applies a conservative HEMS provision that would apply to the trustee while his surviving wife is still alive. However, the husband knows that his adult kids have struggled and he wants them to be able to have ample support after the husband and wife die for the children's health, education, maintenance, and support, reflecting his desire to ease their burdens and prevent them from struggling financially. So when it comes to after husband and wife both pass away, when it comes to that trust for the children that will be in effect until the children reach the age of 60, the husband may in his trust instruments provide a more liberal HEMS provision, and it may include language like the trustee may consider the beneficiary's standard of living prior to the creation of this trust and may distribute trust assets liberally to maintain or improve their standard of living. And then it may go on to say the trustee's decision shall be conclusive and binding, and it is the settlor's intent that the trustee exercise broad discretion in making such HEMS distributions. So in final, I want to say that many trusts have these HEMS distribution provisions which authorize a trustee, even prior to the date that the trust is terminated, it authorizes the trustee to make distributions to a beneficiary for their health, education, maintenance, and support. But you do have that ability, if you want to and if you need to provide a conservative HEMS provision or a liberal HEMS provision. Hope that helps as you're working through creating and maintaining your estate. We'll see you next time.